Good morning. This is Rajeshkumar. Today we are going to discuss about one theory question. We have to critically analyze the specific performance in the English contract law. The video content has been made available for informational and educational purpose only. The question of whether the remedy of a specific performance should be more widely available in English contract law brings into focus the fundamental principles of contract law remedies. Historically, damages are the preferred remedy in common law system like England, while the civil law systems rooted in Roman law places the specific performance as the primary remedy. This SCA critically analyzes and examines whether the specific performance should be more widely applied by analyzing the case law, the traditional preference for the damages, and the exceptions that currently govern the availability of a specific performance. In English law, the primary remedy for the breach of the contract is the award of damages, which aims to put the claimant in the position they would have been had the contract been properly performed. Damages are a monetary remedy, and the courts typically avoid compelling a party to perform specific acts. This contrasts with the civil law system, which emphasizes the importance of enforcing the specific terms of the contract through specific performance. In Bronze Engineering Co. Limited versus Steel Construction Co. Limited in 1972, this case reflects this preference, where the court refused to order a specific performance for the supply of machine, holding that damage were an adequate remedy. The court, reluctant to award specific performance, highlights the practical concern that money, rather than the enforcement, is often seen as an adequate means of remedy of breach of contract. English law emphasis on damages can be seen as reflective of its pragmatic approach. Damages allow the innocent party to recover without forcing the breaching party into further obligations, which may be economically inefficient or unjustified. However, this reliance on damage sometimes fails to account for cases where a monetary compensation is not sufficient, such as contracts involving unique goods or where performance is essential to the injured party's interest. Expanding the specific performance could ensure justice in cases where damages are inadequate to provide a real compensation. The exception to damages, availability of specific performance. The specific performance is an equitable remedy and is granted only in certain situations. The general bar is that it will not be ordered where damages are an adequate remedy. However, the English courts have recognized specific performance in certain circumstances, particularly where the subject matter of the contract is unique or cannot easily be replaced with money. In Becneke versus Bade Shipping Limited case in 1927, where the specific performance was awarded for the sale of unique ship. The court found that the ship was a specific value to the buyer, but due to the specific features and no amount of money could adequately compensate the buyer for the loss of the vessel. This case underscores the exceptional nature of specific performance in contracts involving irreplaceable goods or the property. Similarly, in Sky Petroleum as VIP Petroleum Limited in 1974, the specific performance was ordered because in the context of an oil crisis, the damages would not have adequately compensated the claimant, who was in dire need of a fuel supply. Here, The commercial necessity and the difficulty in obtaining a replacement justified the granting of a specific performance. These exceptions reveals that a specific performance is available when the damages fall short of making the claimant whole. Expanding the availability of specific performance might better address the situations where damages as a remedy are insufficient. For example, in cases involving personal relationship or unique goods, a mere financial award might leave the claimant without meaningful redress. Yet, an overextension of specific performance could burden the courts with supervising the performance of the contract, which may not always be feasible. What are the bars to specific performance and their evaluation? The remedy of specific performance is not available in all cases. Courts have established several bars to its applications, including the contracts for person services. As seen in COP Insurance Insurance Society Limited versus Agril Stores Holding Limited in 1997, the House of Lords refused to enforce a specific performance where it would involve a continuous supervision by the court. This case involved a supermarket that breached a lease agreement, but the court found that forcing the business to continue operating was impractical. Uncertainty. The court will not grant any specific performance for contracts that are too uncertain to be enforced. This is based on the reasoning that the court cannot compel parties to adhere to vague or imprecise terms. Hardships. If specific performance would cause undue hardship to the breaching party, court may deny the remedy. This reflects the equitable nature of specific performance, where fairness plays a significant role. In Girls versus Morris case in 1972, emphasized that specific performance will not be granted where the court would face difficulties in ensuring a proper performance, particularly in contracts involving artistic or subjective performances, where an individual's personal inputs cannot be easily monitored. The application of these bars has become more flexible over time, reflecting evolving commercial realities. However, certain bars, such as refusal to enforce the contracts for personal services, are entrenched. Well, there is a logic to avoid specific performance in personal service contracts due to difficulties of monitoring. It could be argued that expanding the remedy in commercial settings where performance is critical might offer fairer outcomes. Moreover, modern technologies and third-party monitoring mechanism could help overcome the supervisory difficulties courts previously faced. Should the specific performance be expanded? The remedy of specific performance should be more widely available in English law, but only in contexts where damages are clearly inadequate, such as contracts for unique goods or critical commercial services. A reluctance to expand the specific performance has been rooted in the pragmatic concern over the burden on the courts and the risk of inequitable outcomes. But these concerns can be addressed by refining the criteria under which the remedy is granted. In Beswick versus Beswick case in 1968 offers a compelling argument for broader availability of specific performance. In this case, the widow of the deceased was able to claim a specific performance of a promise made to her late husband, ensuring she received the financial support. The case demonstrated that the moral and equitable justification for specific performance when damages cannot ensure justice. To conclude, English law preferences for damages as a primary remedy is well founded, but it often fails to deliver adequate justice in cases involving unique goods, personal relationship, or commercially critical services. The remedy of specific performance should be expanded in a targeted manner, focusing on cases where damages do not provide a meaningful compensation. By doing so, the English contract law could better align with equitable principles while maintaining the balance between fairness and practicality. The court's cautious approach to specific performance reflects a commitment to efficiency, but a more nuanced expansion could enhance fairness in the modern commercial landscape, particularly as technology reduces the burden of supervision. Thank you. Thank you.